The right to free speech must not be trumped by famous people's demands to shield their reputations. This win is precedent-setting, proclaimed Meghan Markle, immediately after last week's Court of Appeal decision against the Mail on Sunday, even though the court took pains to explain that it was not setting a precedent at all. The appeal court judges ruled that this newspaper's decision to publish half of a letter from Meghan to her father had indeed been a breach of her privacy, as she claimed. Yet her win was simply an application of laws that had been developed—in fact, created, by judges over the past 15 years. And this is significant. This case has drawn attention to a dangerous increase in judge-made restrictions on free speech that increasingly prevent our society from holding the rich and powerful to account. Those laws have troubling implications for freedom of expression, and in this case they were applied after a summary judgment, which is to say without a proper trial where the facts and evidence would be closely scrutinized. Now there are loud demands that Parliament should intervene to strengthen our protections for free speech. Our first law to protect privacy came in 1360, before the invention of printing, to punish people who listen under walls and windows, or in the eaves of a house. To frame slanderous and malicious tales. Judges were required to perform a balancing act, weighing inevitably, according to their own values, the importance of each right as it applied to the facts of the case. And so the rich and famous were handed a new legal weapon which was relentlessly taken up by reputation lawyers. The problem of course is that these two rights cannot sensibly be balanced at all. Judges, for example, generally exclude any right to amusement or entertainment, or even the right to enjoy the hypocrisy of public figures. Instead, they solemnly intone that what is of public interest is not to be confused with what interests the public—a mantra that usually enables them to rule against popular newspapers. This newly developed law has had serious impact on public interest reporting. There has been a recent upsurge in threats against publishers and human rights organizations from lawyers in London catering for foreign individuals who fear allegations of corruption or human rights violations. Truth is no defense to a privacy claim, and the cost of fighting an action is a serious deterrent to exercising the right of free speech. Moreover, the right to privacy is not merely subjective, but uncertain and unpredictable. For example, the Court of Appeal said that the Mail on Sunday could potentially have avoided liability by publishing only one paragraph of the letter from Meghan's father. But which paragraph? And any selection would open the editor to the charge of cherry-picking, and where documents are concerned it may be important to see them fully in context. Finding a balance between two incomparable rights is unworkable and subjective. Instead, we should focus on the real question of whether the defendant crossed the red line, that of inhumanity. This does not mean that we should go back to a time when privacy rights did not exist. They are a necessary protection for citizens against cruelty and unfair media demonization. But they must be confined to cases where victims deserve compensation. The growth in privacy claims is just one aspect of laws that increasingly chill investigative journalism, invoked by a growing breed of lawyers who promise the rich and famous to restore their often overhyped reputations. Even national newspapers struggle to pay the exorbitant legal costs of mounting a defense, let alone small publishers and human rights organizations which strive to expose abuses and corruption abroad but are threatened with bankruptcy by the prospect of legal reprisals in London. Increasingly, it may be said that Britain is not a country which has free speech, it has expensive speech. On Thursday, Meghan released a lengthy and incredibly candid statement about the ruling, which she described as precedent-setting and a measure of right versus wrong.